Hey, good morning once again. We will now continue our discussion on the rules of criminal procedure, and we are now on Rule 112. We have already finished discussing Rules 110 to 111, and in fact, we also had our midterms already. So for semifinals to finals, we will start off with Rule 112 or the rules on preliminary investigation. So, just a caveat, there is already a new rules on preliminary investigation issued by the Department of Justice. And it is it is already enforced as of the moment, but the Supreme Court is still on the process of revising the criminal procedures, taking into account the DOJ circular issued by the Department of Justice. But for purposes of having a background and working knowledge on the provision currently of the rules on criminal procedure, we will discuss Rule 112 before we dive into the DOJ circular issued by the Department of Justice. Okay? So in your Rule 112 of the Revised Rules of Criminal Procedure, Section 1 defines what is preliminary investigation. Okay? So here, it says that preliminary investigation is an inquiry or proceeding to determine whether there is sufficient ground to engender a well-founded belief that a crime has been committed and the respondent is probably guilty thereof and should be held for trial. Except as provided in Section 6 of this rule, a preliminary investigation is required to be conducted before the filing of a complaint or information for an offense where the penalty prescribed by law is at least 4 years, 2 months, and 1 day without regard to the fine. So with the current issuance of the DOJ, of a DOJ circular regarding preliminary investigation, this is no longer 4-1, ha? This is no longer 4 years, 2 months, and 1 day. We have discussed this in passing before, no? The provision now in the DOJ circular is 6 years and 1 day. Pataas. Okay? So, ato nang tanawon later. Okay? So, originally, kaning nga rule, no, on preliminary investigation, of offenses or this provided originally for offenses cognizable by the regional trial court, which now integrally consist of one stage regardless of whosoever conducts the same. Okay. In the latest revision in this particular article, this was amended to likewise make preliminary investigation a matter of right. A matter of right in courts of first level, because ato man nagisgutan before, di ba, nga kung below 6 years ang penalty, it's in the first level court or in the MTC. But murag nibalik siya with the original, actually nibalik siya with the original ruling before this rule came into life, no. Nibalik nga it's only offenses cognizable by the RTC nga mo go through preliminary investigation, which we will now look into. Okay, so in the okay, also in a resolution issued by the Supreme Court in 2005, no, it says that uh i-remove na ang conduct of the preliminary investigation from judges of first level courts. Okay? So in the subsequent section, you will see nga it is no longer um included therein na ang mga judges as one of the officers who will be conducting preliminary investigation. You will see there na it's the prosecutors na who will be conducted, because before, one of the officers who are charged with the task of doing preliminary or conducting preliminary investigation is kaning judges sa MTC. But with the revision of the revised criminal or of the criminal procedure under this rule, gitangtang ang judges in the conduct of preliminary investigation. So it's only the prosecutors now. Okay? Now, how did we define ganit preliminary investigation? When we talk about preliminary investigation, it is an inquiry or a proceeding, the purpose of which is to determine whether there is sufficient ground to engender a well-founded belief that a crime has been committed and the respondent is probably guilty thereof and should be held for trial. Okay? So basically, the thing that you must look into preliminary investigation is probable cause. That's in Rule 112. But in the present circular issued by the DOJ, which I believe will also be integrated in the revised criminal procedure that the Supreme Court is drafting as of the moment, no, is that lahi na, ang gigamit na nila ron is reasonable certainty of conviction. Okay, reasonable certainty of conviction. Tanawo na to na later. But for purposes of knowing also the definition of probable cause, mao ni ang probable cause as defined by jurisprudence. Okay, so the evidence necessary to establish probable cause is based only on the likelihood or probability of guilt. So probable cause does not refer to the evidence which would justify a conviction. While it refers to probability of guilt, it requires more than bare suspicion. So maura gyud na ang gi-require sa una. Probably guilty ba ang akusado or ang respondent and should be held for trial. But karon, it has to be proven na naay reasonable certainty of conviction. Ngano ka ni? The reason behind this is that daghan magud kaayong mga anomalous cases or malicious cases filed before the prosecutor's office. To the effect nga bisag waysa ang tao because of the phrase probable cause, mafailan og kaso ang tao. Okay? So that's why they revised it to change the probable cause into reasonable certainty of conviction. So only these are the types of probable cause which I believe will also be changed in the course of time due to the changes in the provision on preliminary procedure and on the preliminary investigation. Ato lang na siyang scan. Okay. So what is really the purpose of preliminary investigation? The purpose of preliminary investigation is to inquire concerning the commission of a crime and the connection of the accused with it in order that he may be informed of the nature and character of the crime charged against him. And if there's probable cause for believing him guilty, that the state shall take the necessary steps to bring him to trial. Second, to preserve the evidence and keep the witnesses within the control of the state. And third is to determine the amount of bail if the offense is bailable. Okay, that's according to Calio Claridad versus Esteban, decided on March 30, 2013. Basically, those are the things that the Supreme Court said are the purposes of preliminary investigation. Also remember that preliminary investigation is not a constitutional right, okay? The holding of a preliminary investigation is not required by the Constitution. The right of preliminary investigation is of a statutory character and may be invoked only when specifically created by statute. But while the right is statutory rather than constitutional, since it has been established by statute, it becomes a component of due process in criminal justice. Okay? So when granted by statute, the right is not a mere formal or technical right. It is a substantive right. And to deny the claim of the accused to a preliminary investigation would be to deny him of the full measure of his right to due process. Okay? And where the denial is tainted with grave abuse of discretion amounting to lack of jurisdiction, a ground for a petition of certiorari and mandamus arises. Okay? So, timan ina na ingon ng Supreme Court, while it may not be a constitutional right, but it is a component of due process. Okay? And if you will not afford the person of his right to a preliminary investigation, that would tantamount to a deprivation of him of his right to due process. Okay? Manina ninyo. In the case of Rodrigo Duterte versus the Honorable Sandigan Bayan, the Supreme Court said that a preliminary investigation is or takes on an adversarial quality and an entirely different procedure comes into investigation or a previous inquiry of some kind before an accused person is placed on trial. And it is to secure the innocent against hasty, malicious, and oppressive prosecution and protect him from an open and public accusation of a crime, from the trouble, expenses, and anxiety of trial. The right to have a preliminary investigation conducted before being bound over to trial for a criminal offense and hence formally at risk of incarceration or some other penalty is not a mere formal or technical right. It is a substantive right. And again, no, to deny the accused's claim to a preliminary investigation would be to deprive him of the full measure of his right to due process. So just look into that. So again, no, in July 16, 2000 or 2024, the Department of Justice issued Department Circular Number 15 or the 2024 DOJ Rules on Preliminary Investigation. So the rules mark a significant change to the conduct of criminal proceedings in the Philippines as they supersede the rules on preliminary investigations previously bound in the rules of court. So here, the rules already cover the procedure of case build-up, preliminary investigation, inquest proceedings in cases involving warrantless arrest and appeals. And they also introduce several innovations such as enhanced prosecutorial rules or roles in case build-up, e-filings, and virtual hearings for both preliminary investigation and inquest. So the rules further detail the new reasonable certainty of conviction standard previously adopted in several DOJ circulars. Okay? So the rules took effect on July 31, 2024, 15 days after being published. So unsa man ang naa sa DOJ Circular Number 15 series of 2014 to 2024. Let's look into this, okay? Okay, so here it is entitled the 2024 DOJ National Prosecution Service Rules on Preliminary Investigations and Inquest Proceedings. So sa Rule 1, gibutang diha, Section 1, the title, the scope. So here, look at the scope, no? This pertains or this shall govern the conduct of preliminary investigations and inquest proceedings in all prosecution, in all prosecution of offices in the National Prosecution Service of the DOJ. Okay? And then the coverage is this, tanawa ha, the conduct of a preliminary investigation proceedings shall be required for crimes or offenses where the penalty by law is at least 6 years and 1 day without regard to fine. Okay? So, from 4 to 1, from 4 years, 2 months, and 1 day, it now becomes 6 years and 1 day. This is irrespective of the fine. Okay? So, this notwithstanding, the investigating prosecutor may motu proprio at any stage of the proceeding dismiss the complaint if there is no prima facie evidence with reasonable certainty of conviction as defined in Section 5, Rule 2 hereof provided. Okay? So, okay, di kayo maklaro sa inyo. So that is now the new ceiling with respect to the conduct of preliminary investigation. It is no longer 4-1 but it is now pila to 6 years and 1 day pataas. Okay? So what is the quantum of evidence required with respect to preliminary investigations and inquest proceedings. So naa na diri ha, akong malikon, it is reasonable certainty of conviction. This quantum exists when a prima facie case is established by the evidence at hand, including but not limited to testimonial evidence, documentary evidence, and real evidence, and such evidence on its own, and if left uncontroverted, shall be sufficient to establish all the elements of the crime or offense charge and consequently warrant a conviction beyond reasonable doubt. The quantum of evidence is met when the prosecutor is convinced that the entirety of the evidence presented by the parties is admissible, credible, and capable of being preserved and presented to establish all the elements of the crime or offense, as well as the identity of the person or persons responsible thereof. Reasonable certainty of conviction also includes a summary evaluation of the evidence presented by the respondents through their counter affidavit. Okay? So, from probable cause, ha, murag ni tuyok, no, og 360 ang requirement or quantum of evidence required in preliminary investigation. It now becomes reasonable certainty of conviction to the effect that the prosecutor should see to it that ang iyahang ebidensya admissible, credible, and capable of being preserved and presented in order to establish the elements of the crime. Kaya sa una, probable cause, basta there is already a probable cause that the respondent is probably guilty of the offense charged and should be held for trial. It is already enough quantum of proof or quantum of evidence. But now, giusab sa DOJ, and what is now required is unsa to reasonable certainty of conviction. Okay? Now, who has the authority to conduct preliminary investigations? All prosecutors, including the prosecution attorneys and other officers, as may be allowed by law, are authorized to conduct preliminary investigation and inquest proceedings. So, state prosecutors or prosecutors assigned at the Office of the Secretary of Justice prosecution staff shall have the national jurisdiction over all crimes or offenses involving criminal cases in which the venues were transferred to avoid a miscarriage of justice, or when so directed by the Secretary of Justice as public interest may require. Okay? The city, the provincial or regional prosecutors and their assistants shall have jurisdiction over crimes or offenses for the violation of ordinances, for over crimes or offenses and violation of ordinances cognizable by the proper courts in their respective territorial jurisdiction. So, same hapon, okay? So, in this rule also, no, gidefine sa nila diri ang preliminary investigation. So, I think it is already safe to assume that in the provision of Rule 112, instead of studying Rule 112, kanina ato ang tunan kaning DOJ Circular number 15 series of 2024. Okay? So, ang definition sa preliminary investigation here is a summary proceeding to determine whether a person should be indicted in court after ascertaining based on the evidence provided and after case build up. Tanawa, oh. Na? Based on the highlight, ha? Based on the evidence provided and the case build-up has been conducted, ha? I-conduct, and there is prima facie evidence with reasonable certainty for the respondent's conviction and that he or she should be held for trial. Okay? Sorry. There is also the so-called virtual preliminary investigation, no, as an alternative means. So it is the conduct of preliminary investigation through video conferencing using the appropriate information and communication technology. And this may be availed of at the initial hearing where both parties are present, and the ICT therefore is available to both the prosecution office and the parties. Okay? Same gihapon ang parties to a preliminary investigation, the complainant and the respondent. Okay? So the complainant here is the offended party, which may be a natural or juridical person. Kaya man tawat is natural person, no? Kita mga humans. Juridical person, these are called persons by virtue of or by operation of law. Okay? Kanang corporations, partnerships, entities that are registered no in accordance with the laws and given personality by operation of law. Muna juridical persons. Okay? So the complainant is the offended party, whether natural or juridical person, a person authorized under existing laws or rules to file complaint affidavit on behalf of the offended party, and a law enforcement agency or any public entity charged with the enforcement of the law violated. So basically the same but naalay gi-add no ang kaninga rules, okay? And then the respondent is the party being charged with the commission of a crime or offense or violation of an ordinance and against whom the complaint affidavit is filed. Okay? Now, let's look at the process, okay? So, the affidavits allowed to be filed or submitted during the preliminary investigation are the following. Basically, pareha ra gyapon no, the complaint affidavit. So, the complaint affidavit is a written statement charging a person with a crime, offense, or violation of an ordinance subscribed by the offended party, a person authorized by Section 5, Rule 110 of the Criminal Procedure, to file the complaint on behalf of the offended party, a law enforcement officer, any other officer charged with the enforcement of the law violated, and sworn before a prosecutor or any government official authorized to administer oath or in their absence or unavailability before a notary public. Okay? So muna ang complaint affidavit. Complaint affidavit. And then after the complaint affidavit, what is now the process is that the respondent will be asked to file a counter affidavit. Unsa man ang counter affidavit? Okay? It is a written statement of the respondent indicating his or her defenses and also subscribed and sworn to be for a prosecutor or any government official authorized to administer oath or in their absence pwede ra sa notary public. Okay? And then, inig-file o counter affidavit ni respondent, pwede pa bang mutubag si complainant sa counter affidavit? The answer is yes, and the complainant will now file a reply affidavit. Okay? Mao ni ang written statement by the complainant which answers new allegations in a counter affidavit, again subscribed and sworn to before the prosecutor or authorized to administer oath or kung wa ng duha before a notary public. Now, after receiving the reply affidavit, can the respondent again reply to that reply affidavit? The answer is yes, okay? And that is what we call the rejoinder affidavit, okay? It is a written statement by the respondent in response to reply affidavit. Same gihapon ang process, ipasord sa prosecutor or any government official charged with the authority to administer oath or kung wa ng duha adto sa notary public, okay? All affidavits as defined above shall include affidavits of witnesses and other documentary evidence attached thereto. Presently, no, the rule under the kanini ang courts, no, tanan na gyud dili lang siya simple complaint affidavit. The requirement now is in the form of a judicial affidavit. That's why the practicing lawyers would call it complaint judicial affidavit, complaint counter judicial affidavit. What is a judicial affidavit? That affidavit is in the form of question and answer. Okay, dili na bitaw katong usual affidavit nga I am the complainant, this is what happened, and ana imurang i-narrate in the form of paragraph form, a 1, 1, 2, 3, 4, ana. What is now the requirement is judicial affidavit ang form. So there will be a question posed by the attorney, and then there will be an answer given by the complainant or respondent as the case may be. Okay? A motion for suspension of proceedings by reason of prejudicial question may be allowed if all the conditions under the existing rules are present. Remember na di pwede ang bill of particulars no nga i-file in lieu of the counter affidavit. Unsa man ang bill of particulars? Ang concept ng bill of particulars is that say you are confused as to the allegations no of the complainant in his or her complaint affidavit. What you would do is instead of filing a counter affidavit, you would file a motion for a bill of particulars clarifying the allegations in the complaint. That is not allowed. What you will do is just file a counter affidavit. Okay? Because under these rules, no motion for bill of particulars shall be filed in lieu of the counter affidavit. Also, no motion or request for extension of time shall be allowed except when the interest of justice demands, such as when a party needs reasonable time or sufficient opportunity to engage the services of counsel to assist him or her during the preliminary investigation, examine or verify the existence, authenticity, or accuracy of the voluminous records, undertake studies or research on novel, complicated, or technical issues uh, involving the case under investigation. Any extension of time granted to submit a responsive pleading on meritorious grounds shall not exceed 10 days. So, namin gini, this could happen because na ay mga respondent nga makadawat og counter affidavit, dili ra nila tagdon na naara by time frame given no ang prosecution's office. So ini doon nilang abogado, there's only like 2 days or 1 day left for them to file a counter affidavit. And the lawyers would be constrained to file a motion for extension or motion for time no para maka-file og counter affidavit. So, i-allow na siya so long as you can prove that the same would be in the interest of justice. Okay? Also note that no motion for inhibition shall be granted unless based on just, valid, or compelling reasons pursuant to prevailing laws, rules, or policies, such as but not limited to the following instances. Una, the prosecutor or his spouse is interested as heir, legatee, or creditor. The prosecutor is related to either party within the sixth degree of consanguinity or affinity, or to counsel within fourth degree of consanguinity or affinity. The prosecutor has been named executor, administrator, guardian, trustee, or counsel of any of the parties. However, a prosecutor may, in the exercise of his or her discretion, disqualify himself or herself for other just or valid reasons, provided the head of the prosecution office has approved the same. Okay, also, no, affidavits of desistance may be allowed only if not prohibited under applicable laws, rules, and existing policies. So let's now look at the procedure, no, for regular preliminary investigation. So the following shall be the procedure in the conduct of preliminary investigation. So the preliminary investigation is initiated by the filing of the original complaint, no, with 2 duplicate copies for official file and such number of copies as there are respondents with the prosecution office. Each complaint affidavit shall be accompanied by a duly accomplished NPS investigation data form. The complaint affidavit shall state, among others, the name, the addresses, basically katong requirement no in Rule 110 in order to have a sufficient complaint. Okay? So kato imong ibutang. And then upon receipt of the complaint affidavit and before the same is docketed, the head of the prosecution office shall ensure sufficiency in form of the complaint affidavit and the completeness of evidence. For this purpose, he or she shall have required the complainant, the referring law enforcement agency, or any third party to submit any lacking piece of evidence. And once the head of the prosecution office determines that the complaint affidavit is sufficient in form and the evidence is complete, the same shall be docketed. So, upon filing, no, tanawon yun ang daan sa prosecutor kung kumpleto ba ang dokumento nga gi-file sa complainant. Kung naikuwang, they can always contact the complainant in order to comply with the lacking requirement. Okay? Now, Kung ang respondent, guys, is CICL or child in conflict with the law, kanang minors ba, kang giakusaran ba. So, the preliminary investigation shall be conducted pursuant to RA 9344 as amended by RA 10630, other applicable issuances, and existing policies on the matter. RA 9344, no, is katubitang law establishing a comprehensive juvenile justice welfare system as amended by RA 10630, or the act strengthening the juvenile justice system in the Philippines. Okay? Let's resume. I'll just use this PDF kay lisod tong akong. Okay. So again, sa to no, upon receipt of the complaint affidavit, i-check yun nun, fiscal, if complete ang tanan nga requirements or evidence required, and then if not, pwedeng ingno ni fiscal, i-kompleto sa ni before nato ni i-docket, okay? And then if the preliminary investigation is to be conducted against a CICL, no, against a respondent who is a CICL or child in conflict with the law, it should be governed in accordance with RA 9344 as amended by RA 1630. Okay? Um, Within 5 calendar days from receipt of the entire records of the investigating prosecutor, he or she shall either recommend the dismissal of the complaint affidavit to the head prosecution office if she finds no that there is no ground to continue the investigation, or pwede siyang mo issue og subpoena, or issue a subpoena, tong usbon ang color, or issue a subpoena, subpoena to the parties to appear before him during the conduct of the preliminary investigation. Okay? The subpoena shall set the date, the time, and place of appearance, okay, for the preliminary investigation hearing, which shall not exceed 30 days from the investigating prosecutor's receipt of the entire case records. The subpoena to the respondent shall include the complaint affidavit and its attachments, and shall direct the respondent to submit his or her counter affidavit and her affidavit of his or her witnesses on the date set for the purpose, which may at least be 10 days from receipt of the subpoena and the complaint affidavit. Okay? For voluminous records, the prosecutor shall set a separate date for the respondent to pick up the entire case records, which must not be less than 10 days prior to the scheduled preliminary hearing. When there are pieces of object evidence, the respondent shall be given the opportunity to examine the same and take photographs at his or her expense. Okay? Now, kanita nawa. During the preliminary investigation, um, hearing, the respondent shall file his or her counter affidavit, which he or she shall subscribe and swear to before the investigating prosecutor or any government official authorized to administer an oath, or in their absence, a notary public. So the respondent or his or her authorized representative shall file the original copy of the counter affidavits. Muna i-file niya. And then, ang personal appearance of the respondent during preliminary investigation may be dispensed with, provided that his or her counter affidavit was subscribed and sworn to by any prosecutor, government official authorized to administer oath, or in their absence, a notary public. Again, kanang motion to dismiss may not be allowed except when it is verified by the respondent and contains his or her defenses, in which case it shall be treated as the counter affidavit if it contains the defenses. Okay? Otherwise, it is not allowed. If the respondent does not appear The investigating prosecutor shall require proof from the complainant that the respondent's address in the complaint affidavit is the respondent's last known address. If despite receipt of the subpoena at his or her last known address, the respondent fails to appear or file his or her counter affidavit without any justifiable reason, si fiscal now may consider the case submitted for resolution. Okay? So muna, after ma-receive ni fiscal ang counter affidavit, iyan na ng tan-awon, no, kung naabay um, reasonable certainty of conviction in order for the case to be filed before the court. Okay? So, pwede sad siyang mag-clarificatory hearing. Okay? In the clarificatory hearing, pwede niyang ipangutana ang clarificatory questions or if okay ra ba nga um, idiretso na lang to submit for resolution or mag-require pa ba siyang filing of the reply affidavit and or rejoinder affidavit. Okay? So the prosecutor may require the filing of the reply affidavit in the counter or if the counter affidavit contains new issues of facts or questions of law which are material as substantial in nature. So in such instances, the respondent shall have the opportunity to file his or her counter affidavit. Okay? Again ha, balik ko na to, upon the filing of the complaint affidavit, the fiscal will check if it is already sufficient in form. If lacking, he or she may require that it be complied with before it will be docketed. After it is docketed, he may require for a preliminary investigation hearing, and during the hearing, no, the respondent will be required to present his or her counter affidavit together with the affidavits of his or her witnesses. Okay, and this should be within 10 days. Okay, within 10 days from the receipt of the subpoena and the complaint affidavit. After that, i-assess ni fiscal, needed pa bang clarificatory hearing or okay na ba nga i-submit na for resolution or mag-require pa ba siya for additional reply affidavit or rejoinder affidavit as the case may be. Okay? So for the procedure in virtual preliminary investigation, you just look into that, no? Let's look at the provision on the inquest proceeding. So unsa nang inquest proceeding? Ato initially gi-discuss before, 'di ba, na um there are instances or there are different instances kung kanus ang makandak ang or if there is a conduct of preliminary investigation or no more preliminary investigation. It could happen. Una, there can be a preliminary investigation if there's a commission of crime. Wala na dakpan ang akusado and you have to prove that there is a reasonable certainty of conviction. Mo file kag complaint and then I counter affidavit and then a tan-awon ni fiscal if na by reasonable certainty of conviction and then filean dayon og information before the court. Naapoy instances wherein we call that kaning gitawag na tog warrantless arrest, okay? Lawful warrantless arrest. In the lawful warrantless arrest, what the prosecutor would do is they will not require you to generally, no, they will not require you to file a counter affidavit. What would happen after that is there will be a conduct of inquest proceedings, okay? Sa inquest proceedings, summary ang may tabuan na, mangutana si piskal unsay nahitabo, diin ka atong mapanghitabo. But during the inquest proceedings, it could be that there be a conduct of preliminary investigation which we will look into, no, kung kanusa pwede nga makakandak og preliminary investigation during the inquest proceedings. Okay? So when we talk about inquest, it is an informal and summary investigation conducted by a prosecutor or other officers allowed by law in cases involving persons arrested, no? Tara ay, arrested and detained without the benefit of a warrant of arrest issued by the court for purposes of determining whether that person should remain under custody and correspondingly be charged in court. Okay? There's also what we call as the e-inquest as an alternative. It is the conduct of inquest through video conferencing using the appropriate ICT. Okay? So what is the procedure for inquest proceedings? Mao ni ang procedure. The inquest proceedings is initiated by the filing of the original of the referral letter, including the duplicate copies for official file and such number of copies as there are the respondents prepared by the law enforcement agency or by a private citizen who arrested the person without a warrant of arrest. Okay? With the applicable period under Article 125 of the Revised Penal Code. Tan-awon gyud na nato nga dapat this will be conducted within the applicable period provided for in Article 125 of the Revised Penal Code. Unsa na nga mga period, nindot ni nga rules, no? Kay nga no, specify na gyud diri tanan. Specific na kaayo ang number of hours. Okay? So, 12 hours for the crime or offenses punishable by light offenses or its equivalent. 18 hours of the crimes or offenses punishable by correctional penalties and their equivalent. 36 hours for crimes or offenses punishable by afflictive or capital penalties or their equivalent. So when the person under custody is a CICL, the inquest will be conducted pursuant still of the Juvenile Justice Act, okay, or other applicable laws on existing policies. So ang referral letter shall include the following: all the required evidence, the affidavit of arrest, the investigation report, the complaint affidavit or judicial affidavit, among others. Okay? So, mo na'y ma-happen during the inquest proceedings. Timan ang number of hours, 12, 18, 36. Kailangan the inquest proceedings must be conducted within the applicable period. Otherwise, buhian na dapat ang respondent or ang person under the custody of the law. Okay? So, the docket section shall then immediately forward the referral to the head of the prosecution office or his or her designated prosecutor, who shall provisionally determine the validity of the warrantless arrest for purposes of ascertaining whether the person detained shall remain in custody and shall be charged with the crime for which he or she was arrested without a warrant. Should the warrantless arrest be valid, the referral shall be evaluated for completeness of the required evidence that will establish the elements of the crime or offense and the availability of testimonial, real or object, and documentary evidence. Only referrals determined to be complete shall be docketed. Okay? So during the inquest proceeding, kaniha, during the inquest proceeding, the prosecutor shall ensure that the respondent is represented by counsel and that the said counsel has received the referral and its attachments. The inquest proceeding or the inquest prosecutor shall explain to the arrested person the nature of the proceedings, the charges against him, and his option to avail his or her right to preliminary investigation. Thereafter, the inquest prosecutor shall administer the oath of the affiance and whenever necessary, conduct a clarificatory question to clarify factual matters. Okay? Now, kani, kung ang respondent would opt for a conduct of preliminary investigation, kailangan niya nga i-waive ang provision on Article 125. Okay? So, kung i-waive na niya, he can no longer say nga, oh, you have to release me ha because you are already violating Article 125 of the Revised Penal Code. That's why, if the respondent during the inquest proceedings would opt to have a conduct of preliminary investigation, the prosecutors would really require him or her to sign a waiver of the provisions of Article 125. Okay? Now, notwithstanding the said waiver, the respondent may apply for bail and the investigation must be terminated within 15 calendar days from its inception. The inquest prosecutor shall immediately resolve the case discussing the following matters. Una, provisional determination regarding validity of the warrantless arrest. Ikaduha, the existence of prima facie evidence with reasonable certainty of conviction. So here, if mauna iyang makita during the inquest investigation, the prosecutor shall now prepare the information, okay, and file it before the court. And then procedure and e-inquest, just read that. So, nahuman na no ang conduct of preliminary investigation and inquest proceedings. What happens next is the issuance of a resolution. Okay? So, when we talk about resolution, this is the ruling or the disposition of the prosecutor on the preliminary investigation and inquest proceedings, which determines whether an information should be filed in court or the complaint should be dismissed. Okay? So, diha makita kung mura na siyang desisyon ba sa korte. We call that resolution before the prosecutor's office. Okay? Diha makita if filean ba og kaso or dismiss ba ning kasuha. Okay? Filean ba information or this should be dismissed. Okay? So we already know what is the definition of information. No? It is an accusation in writing charging a person with a crime or offense subscribed and certified by the prosecutor and filed before the proper court. Okay? It shall be in the name of the people of the Philippines and against all persons who appear to be responsible for the crime committed. Okay? So there, mauna siya. There should be a certification by the prosecutor. And then, kani, if the prosecution determines based on evidence that there is no prima facie evidence with a reasonable certainty that the respondent will be convicted once tried in court, he or she shall dismiss the complaint with authority or approval of the head prosecution office. So here, ang prosecutor, iya gyud dapat is-cite ang legal grounds and basis for the dismissal of the complaint in his resolution, in his or her resolution, provided that the dismissal shall be without prejudice and may be refiled when additional pieces of evidence are produced upon further case build-up, as the case may be. Okay? When the investigating prosecutor demands the dismissal of the complaint, but the recommendation is disapproved by the head of the prosecution office on the ground that there exists a prima facie evidence with a reasonable certainty of conviction, the latter may file the information against the respondent or direct another prosecutor to do so without conducting another preliminary investigation. And if the prosecutor determines that there is prima facie evidence with reasonable certainty, who he or she shall have a resolution recommending the filing of the information in court, and he shall henceforth prepare an information. Okay? So these are the periods to resolve cases. Ideally, ang preliminary investigation shall be resolved within a period of 60 days from the date of the assignment with a maximum of 30-day extension, okay? For capital offenses, complex issues, encounter charges, consolidation of related complaints, and reassignment. So ideally, within 90 days, mahuman ang preliminary investigation. Okay? And then, all right. Kani. The aggrieved party may file a motion for reconsideration of the resolution within 15 days from receipt. So, if the parties no are aggrieved of the decision of the prosecutor conducting the preliminary investigation, um the parties or the aggrieved parties may file an MR or motion for reconsideration. 15 days ang period, ana, okay? And the motion for reconsideration shall be assigned to the investigating prosecutor or another prosecutor within 3 days from the filing thereof, and it shall be resolved within 30 days from the date of assignment. And then, after ana, if aggrieved gyapon mo and dili makadaog ang either party, no, and wants to further question the resolution of the prosecutor, so resolutions of the prosecutor general or the regional prosecutor on preliminary investigation or motion for reconsideration may be subject to a petition for review, okay? Or appeal pursuant to this pursuant to the circular number 27 series of 2022, provided that the petition for review shall be accompanied by a motion to suspend proceedings as filed with the court. Because there will be instances, manggod, na even if mo-file ka og MR or mo-file kang petition for review, the case has already been filed before the court, and the courts would push through with the proceedings thereon. So when you file a petition for review, no, after the denial of the motion for reconsideration, be sure to also accompany the same with a motion to suspend the proceedings before the court, okay? However, the resolutions of the Prosecutor General or the regional prosecutor on appeal of the cases cognizable by first-level courts shall be final and no longer be appealable in the Office of the Secretary of Justice. Okay? Tanawan ninyo ha. Kung cases before the MTC and there's already a resolution by the Prosecutor General or Regional Prosecutor, di na pwedeng mo apilar. Okay? Before the Secretary of Justice. And then the resolution of the Secretary of Justice on appeal in criminal cases cognizable by RTC shall be final, executory, and non-appealable, provided that the cases was covered in Section 18 of the Administrative Number 22 Series of 2011. Sa mga appeals and decisions or resolutions or orders of the DOJ shall continue to be limited to those involving crimes punishable by reclusion perpetua to death. And under Memorandum Circular 58, they may still be elevated before the office of the President. Okay? Kung sa maning naa sa Memorandum Circular number 58, mao na ang katong decisions of the Secretary of Justice on preliminary investigations. Except, of course, those cases punishable by reclusion perpetua. I will be giving you a copy of this circular, okay? So for the meantime, that there is no revised criminal procedure yet, containing Rule 112, kani sa inyohang studyuhan, okay? The DOJ Circular number 15, series of 2024, okay? You might be asking, pwede day na, attorney, na ang DOJ kay mo ay magbuhat og rules regarding criminal procedure, di ba? The rule-making power is vested with the Supreme Court. Mauna nga naay administrative matter number 24-0209-SC answering that question. So this is regarding the draft of the Department of Justice regarding the rules on preliminary investigation. So this is what the Supreme Court said with respect to that matter. So ningon na Supreme Court, the Court Subcommittee on the Revision of the Rules on Criminal Procedure request from one of its members from the DOJ a copy of the draft of the DOJ circular on the proposed rules on preliminary investigation. Coincidentally, the court's rules on preliminary investigation are among those to be revised under the proposed rules on criminal procedure. Okay? Thus, to ensure harmony, naningon ng Supreme Court, to ensure harmony between the DOJ's conduct of preliminary investigation or inquest proceedings and our existing court procedures, the subcommittee solicited comments from the members of the bank. So in the letter dated October 27, 2023, addressed to the Undersecretary of the DOJ and CJ of the Supreme Court, Chief Justice Gismundo, transmitted the comments of the members of the bank to the DOJ for its consideration. So through a letter dated January 22, Yusek Vasquez highlighted the matters adopted by the DOJ from the court's comments and its final revision. So basically, konsulta ang DOJ before they finalized their draft before the Supreme Court. And the Supreme Court replied to them containing comments regarding their draft. And the Chief Justice wrote a letter dated February 7, 2024, addressed to the bank, urging its member to recognize the authority of the DOJ to promulgate its rules consistent with jurisprudence that the conduct of preliminary investigation is not a judicial function and part of the prosecution's job, a function of the executive. So timan-i din ninyo nga principle nga ang preliminary investigation is not daw a judicial function but an executive function, okay? Because the DOJ is under the executive branch man, 'di ba? Kamo naman ta, there are three branches of the government, 'di ba? The executive, the legislative, and the judiciary. So niingon ang Supreme Court, even in the long line of cases, no, handed down by the Supreme Court, nga ang kaning preliminary investigation and inquest proceedings, no, this is not a judicial function. This is an executive function. Therefore, the DOJ can promulgate its own rules, consistent, of course, with the rules provided for by the Supreme Court with respect to the rules on criminal procedure. Okay? In this administrative matter, the Supreme Court also gave the brief history of the rules on preliminary investigation. So, may I request Sherwin to read this brief history on the rules on preliminary investigation?
Yes, Attorney. A brief history of the rules of preliminary investigation. Under the Rules of Court promulgated in 1940 Rules of Court, preliminary investigation is defined as a previous inquiry or examination made before the arrest of the defendant by the judge or officer authorized to conduct the same, with whom a complaint or information has been filed imputing the commission of an offense cognizable by the court of first instance for the purpose of determining whether there is a reasonable ground to believe that an offense has been committed and the defendant is probably guilty thereof, so as to issue a warrant of arrest and to hold him for trial. The 1964 version of the Rules of Court, 1964 Rules of Court, essentially maintains such a definition but used the term preliminary examination instead of preliminary investigation. In People versus Montelia, the court ruled that our statutory rules and jurisprudence required prima facie evidence, which was of a higher degree or quantum, and was even used with dubity as equivalent to probable cause. It noted, however, that such problems and confusing concepts were clarified by the 1985 amendment of the Rules of Court. The 1985 Rules on Criminal Procedure reverted to the term preliminary investigation, which it defined as an inquiry or proceeding for the purpose of determining whether there is sufficient ground to engender a well-founded belief that a crime cognizable by the regional trial court has been committed, and that the respondent is probably guilty thereof and should be held for trial. This definition was maintained in the revised Rules of Criminal Procedure promulgated in 2000 rules. As noted in Montelia, the quantum of evidence required in preliminary investigation is such evidence as suffices to engender a well-founded belief as to the fact of the commission of a crime and the respondent's probable guilt thereof. In Hasim versus Boncan, the court has clarified that the purpose of preliminary investigation is to determine probable cause. It is for the presentation of such evidence only as may engender well-founded belief that an offense has been committed and that the accused is probably guilty thereof. This was reiterated by the court in Supreme Court Circular Number 12-87 when it discussed the mandate of judges under the 1987 Constitution in personally determining the probable cause for the issuance of a warrant of arrest. The court stated that the judge may either rely upon the fiscal certification of the existence of probable cause or disregard said certification and require the submission of supporting affidavits to aid in the determination of probable cause for the issuance of a warrant of arrest.
Thank you. Thank you, Sherwin. So that's basically
Thank you, Attorney.
thank you, the history of the preliminary investigation. Now, also in this administrative matter, the Supreme Court discuss the authority to conduct preliminary investigation. So the conduct of preliminary investigation has been shared by the judiciary and the executive up until the revision of the 2000 rules in 2005. Because kaniadto appeal ang mga judges no in the conduct of preliminary investigation. So the judiciary's authority to conduct preliminary investigation can be gleaned from RA number 296 as amended by RA 3828 or the Judiciary Act of 1948 and the Batas Pambansa bilang 29 no or the Judiciary Reorganization Act of 1980. So under RA number 296 as amended, justices of peace and judges of the municipal courts of chartered cities may also conduct preliminary investigation for any offense alleged to have been committed within their respective municipalities and cities, which are cognizable by the RTC. Kining CFI mo ni ang RTC na karon. And the information filed with their courts without regard to the limits of the punishment. Pag 1981, the Batas Pambansa bilang 129 was enacted, authorizing judges of the MTC except those in the capital region of the MTCs and MCTCs to conduct preliminary investigation of crimes alleged to have been committed within their respective territorial jurisdictions, which are cognizable by the RTC. Meanwhile, the executive's authority is also reflected in RA number 732, 5180, and 10071. Under the Republic Act number 732, a provincial fiscal is given the authority to conduct investigation into the matter of any crime or misdemeanor and have the necessary information or complaint prepared or made against persons charged with the commission of the offense. Under the 1940 Rules of Court, the following have the authority to conduct preliminary investigation: Justice of Peace, Municipal Judge, City Fiscal, Municipal Mayor, appeal pagani kaniadto, okay? On the other hand, in the 1985 Rules of Criminal Procedure, it only provides for the following nga makandak sa preliminary investigation: ang provincial fiscals, the judges of the MTCs and MCTCs, the national and regional state prosecutors, okay? The 2000 rules on one hand, maintain the enumeration in the 1985 criminal rules of procedures. But in 2005, ang mga judges sa MTC and MCTCs were already removed from those authorities or from those individuals authorized to conduct preliminary investigation. And mao na karon ang prevailing rule. While sa una appeal ang judges to conduct preliminary investigation, karon ang naa na lang mga prosecutors na lang. State prosecutors, regional and state prosecutors, city and provincial prosecutors. Those are the individuals who are now among those authorized to conduct preliminary investigation. Okay? Okay, so when is it required? Okay, these are just matters of reading, no? Basahan lang yan ninyo. And kani, so again, let's reiterate no that the authority of the DOJ to promulgate its own rules and its repercussions on Rule 112 of the rules. So as illustrated above, preliminary investigation is a vehicle kuno according to the Supreme Court to determine whether a person should be indicted, used to be a function shared by judges and prosecutors. So the paradigm, however, shifted to one of exclusivity in favor of the public prosecutors. So as early as 1986, the Supreme Court has held that the conduct of preliminary investigation is an executive and not a judicial function. Kani nga concept ba guys ni gawas na ni sa bar no gipangutana nga unsa ang concept sa preliminary investigation. So always note that principle that it is an executive and not a judicial function. So in this case, the Supreme Court said that the preliminary investigation is intended to protect the accused from the inconvenience, the expense, and burden of defending himself in a formal trial until the reasonable probability of his guilt has been ascertained in a fairly summary proceeding by a competent officer. It is also intended to protect the state from having to conduct useless and expensive trials. So Section 1, Rule 112 of the present Rules of Court states that it is conducted for the purpose of determining whether there is sufficient ground to engender a well-founded belief that a crime has been committed. The preliminary investigation proper, therefore, is not a judicial function. It is part of the prosecution's job, a function of the executive. Okay? So, muna ang stress sa Supreme Court. And then, finally, ng Supreme Court, for these reasons, the court hereby recognizes the authority of the Department of Justice to promulgate its 2024 DOJ National Prosecution Services Rules on Preliminary Investigation and Inquest Proceedings. Thereafter, and once the DOJ rules are promulgated by the DOJ, the pertinent provisions of Rule 112 of the 2000 Revised Rules on Criminal Procedure as amended, inconsistent therewith, are deemed repealed. This shall be without prejudice to the court's promulgation of its own rules of procedure of a new rule touching upon preliminary investigation consistent with the 2024 DOJ-NPS rules. Okay? So, klaro ang giingon sa Supreme Court in this Administrative Matter 24-02-09-SC, no, na provisions that are inconsistent with the provisions of the 2024 DOJ-NPS rules, no, shall be considered repealed. And of course, this is without prejudice sa court's promulgation of its own rules of procedure because the Supreme Court now is on the process of promulgating the new rules under 112, of course, consistent also with the 2024 DOJ-NPS rules. So, again, akong i-emphasize na for Rule 112, the rules that we should be studying now is the DOJ number 15 series of 2024. Okay? And also take into consideration if maglibog mo nga naman ang buot-buot man ng DOJ, pwede din na nga rule-making power is lodged with the Supreme Court man, amo man ang gitun-an. You also note of Administrative number 24-02-09-SC. Okay? I will be providing you with the copies of these notes. All right. So, okay, look into. We will now discuss the provision or the Rule 113 or arrest. Okay, Rule 113 or arrest. Ako sa check if it's. Okay. So that's Rule 112. No? Again, Rule 112 is repealed by DOJ number 5 series of 2024. So let's now proceed to Rule 113 or the rules with regard to or the rule with regard to arrest. Okay, so how do we define arrest? Arrest is the taking of a person into custody in order that he may be bound to answer for the commission of the crime. For police officers, you know this, how arrest is made. This is by actual restraint of a person to be arrested or by his submission to the custody of the person making the arrest. No violence or unnecessary force shall be used in making an arrest, and the person arrested shall not be subject to a greater restraint than is necessary for his detention. So, ang purpose why a person is arrested is for the specific purpose of making him answer for the commission of an offense. Again, ato ang balik ko no, the process ganiha, there's a commission of the crime. So you will now look into after na-commit ang crime. Unsay sunod ana attorney? You look at the instance. Unsa man na siya, nadakpan siya without a warrant. Unsa man ni siya, wa pa siya nadakpan without a warrant. So okay, regular filing ta. Is there a requirement for the conduct of preliminary investigation? Tan-aw nimo unsa may penalty ani? 6 years and 1 day ba ni pataas or 6 years pa ubos ra ni? So, if tanaw nimo 6 years pa ubos ra ni, you can file directly the complaint before the court. If it requires for the conduct of preliminary investigation, you go to the prosecutor's office, file the complaint affidavit there, and have the conduct of the preliminary investigation. If this is a warrantless arrest, lawful warrantless arrest, what is next? So, what is next now is the conduct of the inquest proceedings. Okay? Sa inquest proceedings, kung warrantless arrest na siya, dili na ni musod ang Rule 110. Okay? Dili na musod ang Rule 110 kung na ay gi-file kang complaint, there is still a conduct of preliminary investigation, and then the prosecutor would now issue a resolution recommending for the filing of an information. Once the information is filed before the court, diha na dayon mo issue og warrant of arrest ang korte. Once the warrant of arrest is issued by the court, arestuhon na karon ang person. Okay? In order for him to answer for the commission of the offense. Okay? So, kung under Section 2, kung ma-arrest ka, a person need not be actually restrained by the person making the arrest. Under the rules of court, a submission to the custody of the person making the arrest already constitutes an arrest. Okay? Note, however, no, inyo na ning naagian because you're already studying government, I think, karon nga, there are instances nga arrest may not be made when it comes to the members of Congress. Remember mo ana nga provision, okay? The members of Congress, no, under Article 6 of the 1987 Constitution provides that um a senator kuno or a member of the House of Representatives shall in all offenses punishable by not more than 6 years imprisonment be privileged from arrest while the Congress is in session. Okay? In all offenses punishable by not more than, meaning less than 6 years. Okay? So no member shall be questioned nor be held liable in any place for any speech or debate in the Congress or in any committee thereof. Also, the heads of the state, diplomatic officers, and their duly registered domestics are likewise immune from arrest, and a violation of this immunity will render the arresting officer as well as those who procured such arrest criminally liable. Okay? Now, what are the requisites for the issuance of a warrant of arrest? Okay? It is constitutionally mandated, no, that a warrant of arrest shall issue only upon the finding of a probable cause to be determined personally by the judge. So the purpose, um, again, we will change that, no, reasonable certainty of conviction. Okay, pero when it reached to the judge, um, I would still presume that the rule that would apply is this, na no search warrant or warrant of arrest shall issue except upon probable cause to be determined personally by the judge after examination under oath or affirmation of the complainant and the witnesses he may produce, and particularly describing the place to be searched and the persons or things to be seized. So lahi na po ni siya nga determination. Once madawat ni judge ang information and the resolution recommending for the filing of the information, tanaw na ni judge, is there a probable cause for me to issue now a warrant of arrest? Okay, so if the judge would find that there's a probable cause to issue the warrant of arrest, he or she will now issue the warrant of arrest. Okay, so in satisfying himself in the existence of a probable cause for the issuance of a warrant of arrest, the judge may do the following procedures. Okay, he or she may rely upon the fiscal certification of the existence of probable cause, Whether kaning probable cause, consider this as the existence of reasonable certainty of conviction, ha. Whether or not the case is cognizable by the RTC, and on the basis thereof issue a warrant of arrest. And if on the face of the information he finds no probable cause, he may disregard the prosecutor's certification and require the submission of supporting affidavits of witnesses to aid him in arriving at a conclusion. Nakasuway ko ani na after reviewing the case, ang judge ba, she felt that kulang ang ebidensya nga gipresent sa prosecution. So what she did is that she required additional supporting affidavits of witnesses to aid the said judge in arriving at a conclusion. So nakapuno pod ang prosecution muna na she was able to push through with the issuance of a warrant of arrest. Okay, so the judge can do that. Okay, so upon the arrest, no, the following may be confiscated from the person arrested. Tanawa lang na ninyo, no? It's provided for in the rules. Ang mga object, subject of the crime, mao na pwede nang i-confiscate. But also note, kabawaan ni si Sherwin, that also note of the underlying rule governing arrest pertaining to prohibition against the use of violence or unnecessary force in making an arrest. The rule emphasizes that no person arrested shall be subject to a greater restraint than is necessary for his detention. Okay? So, if dili required nga violent kaayo imong pag-arrest niya, you don't have to do that. If pwede ra nimong mahangyo, you can always do that as the arresting officer. Okay? Except kung mo na terms sa mga police, no, nga, except kung nanlaban. Okay? Kaya you can also um, exercise due diligence and do something to protect also yourself from those nanlaban. Now, duty of the arresting officer, it shall be the duty of the officer executing the warrant to deliver him to the nearest police station without necessary delay. And then the head of office to whom the warrant of arrest was delivered for execution shall cause the warrant to be executed within 10 days from its receipt. Question: if the warrant is not executed within 10 days, no, will the said warrant of arrest expire? Is there an expiration period for a warrant of arrest?
Wala, attorney.
Yes. Unlike a search warrant, no, kaning 10-day period stated here in this section, no, is not the lifetime or period of enforceability of a warrant of arrest. Ang kanilang warrant of arrest or the said warrant of arrest does not become ineffective or does not expire just by mere lapse of time. Okay? Ang enforceability ana nga warrant of arrest is indefinite, and it is enforceable until such time as the arrest of the person or persons named therein has not been effected. Okay? However, under this section, section 4, within 10 days, ang head of office to whom the warrant was issued must cause the execution thereof. And failing which, the officer assigned thereof must have the corresponding return to the issuing judge within 10 days from the lapse of the original period. You must know, I'm sure we know that knows this because he's a police officer, that ang mga warrant ron, i-warrants na lang. So, dali ra kayo makahibaw ang mga police no nga there is a warrant because electronic naman ang warrant, they can always see it na in the sa natawag nila murag na portal sila anak. Okay, so unless specifically provided in the warrant, the said warrant remains enforceable unless it is executed, recalled, or quashed, even if it is returned and served by the arresting officer because the person named therein cannot be found. And again, the said warrant will continue to remain on file for subsequent service. Okay. So ganiha atong gi-touch no nga there are arrests which are considered lawful even without a warrant of arrest. Okay? So kanus aman ni nga mga instances. Kaning When in his presence, the person to be arrested has committed, is actually committing, or is attempting to commit an offense. When an offense has just been committed and has probable cause to believe, based on personal knowledge of facts or circumstances, that the person to be arrested has committed it. And when the person to be arrested is has escaped, ang una kaning caught in flagrante delicto, ikaduha kaning gitawag natong hot pursuit, no? Ikatulo kanang when the es when the person is an escapee, okay? When he has escaped a penal establishment. So, again, ang general rule yun na is that kung wala kay warrant of arrest, no, wala kay valid warrant, or even in searches, no, if you do not have a valid search warrant, you cannot arrest or search or seize anything without a valid warrant issued by a competent judicial authority. Mao na nga the doctrine is that a valid warrant of arrest is required before an arrest may be made. Ang exception lang ana is kaning atoang Rule 113, which is a warrantless arrest. Okay? This is an exception. So, diri aning
Attorney,
exception.
ay,
Yes, Sherwin?
pwede attorney, mag-clarify lang.
Yes, 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 yes. Unsa man? Yes,
Can
Sherwin.
we contest the issuance of warrant of arrest to the court issuing the warrant?
Who will contest man? The accused?
Yes, attorney.
Yes, they can. In fact, there is a motion, no, that most of the accused would do, no, kaning gitawag nilag motion to quash the warrant of arrest on the
Yes,
basis, no. Oh, ang uban ana mayon sila, there was no conduct of preliminary investigation ana. um
yes, attorney.
Oh, so the basis for the issuance of the warrant of arrest is actually grounded on a violation of their right to a preliminary investigation. So muna ilang ipakwash ang warrant of
Tapos
arrest.
attorney,
Mm.
di ba kami attorney, kung requestion ng warrant, kami mga officer attorney, we are still obliged to enforce it.
Yes,
Uh, uh,
you're still obliged so long as the warrant is still existing, wala pa na-quash. So kung na-quash na ang warrant, you have no warrant to enforce to in the first place, 'di ba? So bisan
uh,
pending pa na diha ang ilahang motion to quash the warrant, still because wala pa may resolution ang korte, kung i-quash ang warrant, imo gyapon nang i-arrest, except of course for
na-confuse lang ako attorney kay
Mhm.
like na in the case of attorney Kibuloy, Pastor Kibuloy,
Ah,
uh, his lawyer insisted that the warrant should be the implementation of warrant should be ceased because it is under appeal.
dili.
Oh, na-confuse lang ko attorney kaya
Mm.
gina-insist magid niya nga di
Oh,
dapat ikuan
yes, mao na
kina-question pa
ilahang
daw.
kuan. Mao na ilahang defense sad. Mao sad ilang defense. But still, I think Kibuloy was arrested.
Yes, attorney, he was arrested.
Yeah, he was arrested by virtue of the warrants. Okay. Thank you for that, Sherwin. So, diri sa again, no, balikta in section 5, these are the instances where an arrest may lawfully be made without a warrant. And in fact, pwede gani ang private person can do so, no? In which case we call that the citizen's arrest, okay? The substantial revision lang of this section was effected in paragraph B, which now only requires that the person making the arrest has probable cause to believe, based on personal knowledge of facts or circumstances, that the arrestee is responsible for an offense which has just been committed. But just a caveat, basig inig-revise ni ani sa Supreme Court, no, sa rules on criminal procedure, basig mausab na sad ni nga requirement. Let's just see. But for now, for purposes of course, studying criminal procedure while still waiting for the passage of the revised criminal procedure, kani sa ato ang tan-awon, okay? In addition to the situations contemplated in this section, arrest without a warrant may also be made where a person who has been lawfully arrested escapes or is rescued by the bondsman for the purpose of surrendering the accused, or where the accused attempts to leave the country without permission of the court. Even if nakabail ang tao, no, na may nadakpan and then posts a bail, even if you are bonded, and if you want to go out of the country, in fact, even if you would just go outside of the territorial jurisdiction of the court handling your case, you have to ask permission from the court. So if mapamatud-an na you went outside of the jurisdiction of the court, or worse, you went outside of the country without the permission of the court, or leave the country without the permission of the court, you may be arrested, okay? Also, even if the instances not allowed by law, a warrantless arrest is not a jurisdictional defect, and the objection thereto is waived when the person arrested submits to arraignment without objection. And the subsequent filing of the charges and the issuance of corresponding warrant of arrest against the person illegally detained will cure the defect of that detention, according to the case of Harvey versus Santiago. Okay. Jurisprudence also tells us that for a warrantless arrest of a person caught in flagrante delicto under paragraph A of this section, in order for that to be valid, na ay two requisites nga kailangan mo concur, okay? Una, the person to be arrested must execute an overt act indicating that he has just committed, is actually committing, or attempting to commit a crime. And ikaduha, such overt act is done in the presence or within view of the arresting officer. And in this type of warrantless arrest, the person making the arrest himself witnesses the crime and should have a personal knowledge of the commission of the crime. Kaning example, kung si Sherwin makakita mismo nga nagpabuto og pistola or gipabutag pistola ni Michelle si X na. So Sherwin in this case has personal knowledge of the commission of the crime committed by Michelle. Okay. A jurisprudential illustration of an arrest in flagrante delicto is one made after conducting a buy-bust operation. That's also an example. Let's look at this case, no, of People versus Collado, illustrating that example. So here, si P.O. Noble received an information from a civilian asset that spouses Marcelino and Myra were engaged in selling shabu and drug users, including out-of-school youths who were using their residence in Pasig for their drug sessions. So a buy-bust operation team was thereafter formed, and the asset introduced P.O. Noble to Marcelino as a regular buyer of the shabu. Myra accepted the money. Si Marcelino then took from his pocket a small metal containing from which he brought out a small plastic sachet containing white crystalline substance and gave it to P.O. Noble. Meanwhile, si SPO2 Cruz and another police officer went inside the house of Marcelino and Myra, where they found Apello, Cipriano, Ranada, Abache, Sumulong, Madaran, and Latario gathered around the table littered with various drug paraphernalia, such as an improvised water pipes, strips of aluminum foil with traces of white substance, disposable lighters, and plastic sachets. A strip of aluminum foil used for smoking marijuana was also recovered from Ranada. So the RTC found Marcelino and Myra guilty of sections 5, 6, and 11 of RA 9165. Si Apelo, Cipriano, Renada, Abache, Sumulong, Mandarang, and Latario are guilty of section 14 of RA 9165. So the Court of Appeals affirmed the decision with modification that Apelo, Abache, Sumulong, and Mandarang are accessories and not principals. Okay? So ang issue here is that whether or not irregularities attended the arrest, detention, and the procedure in handling the specimens seized from them. According to the Supreme Court, the presumption of regularity in the performance of official duties must be upheld in the absence of clear and convincing evidence to overturn the same. So this is the presumption that is enjoyed by law enforcers, no? When they conduct by-bus operations, the presumption is that what they do is regular and in the performance of their official duties. So here, silang Myra argued that the arrest, search, and seizure conducted by the police were illegal since it was not supported by a valid warrant. They thus posit that their right to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures was violated. They also cited the provision of um, the Supreme Court then cited the provision on Section 5, Rule 113. And it said that Section 5A is what is known as the arrest in flagrante delicto. And for this type of warrantless arrest to be valid, two requisites must concur. Katotong gayon ganiha. And then the Supreme Court also said that a common example is an arrest in flagrante delicto, and it is one made in conducting a bypass operation. So a common example, according to the Supreme Court, of an arrest in flagrante delicto is one made after conducting a bypass operation. This is precisely what happened in the present case. The arrest of the appellants was an arrest in flagrante delicto made in pursuance to Section 5A of the Rule 113 of the Rules of Court. The arrest was effected after Marcelino and Myra performed the overt act of selling to PO2 Noble the sachet of Cebu and Renada of having in his control and custody illegal drug paraphernalia. Thus, there's no logical conclusion than that the arrest made by the police was a valid warrantless arrest, since the same was made while the appellants were actually committing said crimes. Okay? Further, according to the Supreme Court, assuming that irregularities indeed attended the arrest of the appellants, they can no longer question the validity thereof, as there's no showing that they objected the same before arraignment. Neither did they take steps to quash the informations on the said ground. They only raised the issue upon their appeal to the appellate court, and by omission, any objections on the legality of the arrest are deemed to have been waived by them. And that their claim of unreasonable search and seizure, it is true that under the Constitution, a search and consequent seizure must be carried out with the judicial warrant. Otherwise, it becomes unreasonable, and any evidence obtained therefrom shall be inadmissible for any purpose in any proceeding. This proscription, however, admits of exceptions ng Supreme Court, and one of which is warrantless search incidental to a lawful arrest. The arrest of the appellants was lawful, and under Section 13, Rule 126, katong mo niyang provision on search warrant, guys. Person lawfully arrested may be searched for dangerous weapons or anything which may have been used or constitute proof in the commission of an offense without a search warrant. The factual milieu of this case clearly shows that the search was made after the appellants were lawfully arrested. Pursuant to the above-mentioned rule, the subsequent search and seizure made by the police officer were likewise valid. Hence, the appellant's claim unreasonable search and seizure must fail. Okay? So again, no, niingon ng Supreme Court na kanang arrest, ang common example of an arrest in flagrante delicto is one made after conducting a bypass operation. That's a common example. Another case is the case of O'Meal versus Ramos. In this case, the military agents received confidential information that a certain man named Ronnie Havillon, believed to be one of 5 NPA sparrows who recently murdered 2 Capcom mobile patrols, was being treated in a hospital for having gunshot wounds. So later on, it was found out that Ronnie Havillon is a fictitious name and that his real name is Rolando Dural. Rolando Dural was transferred to the Regional Medical Services of Capcom for security reasons. Meanwhile, he was positively identified by the eyewitnesses as the one who murdered 2 Capcom mobile patrols. In this consolidated cases, it assails the validity of the arrest and searches made by the military on the petitioner. That a mere suspicion that one is a Communist Party or New People's Army member is a valid ground for his arrest without a warrant. So the issue here is whether or not the warrantless arrest is valid. According to the Supreme Court, yes, the arrest without a warrant is justified because it is within the contemplation of Section 5, Rule 113. Dural was committing an offense when arrested because he was arrested for being a member of the New People's Army, an outlawed organization where membership penalized, and for subversion, which, like rebellion, is a continuing offense. Given the ideological content of membership in CPP-NPA, which includes armed struggle for the overthrow of organized government, Dural did not cease to be or become less of a subversive for purposes of arrest simply because he was, at the time of the arrest, confined in St. Agnes Hospital. So in this case, the Supreme Court also upheld his arrest under Section 5, Rule 113. Now, the second instance of a lawful warrantless arrest covered by paragraph B, cited in Section 5, Rule 113, no, necessitates two stringent requirements before a warrantless arrest can be made. First, an offense has just been committed, and that the person making the arrest has personal knowledge of facts indicating that the person to be arrested has committed it. So, under this exception, the law enforcers need not personally witness the commission of the crime, but they must have personal knowledge of facts and circumstances indicating that the person sought to be arrested committed it. In fact, the offense um was not committed in his presence, although said offense, as required by the rules, has just been committed. Lahi siya sa paragraph 1 because sa paragraph 1 naagi personal knowledge. But here, personal knowledge of facts lang in paragraph 2. Okay? The tenor of the rule obviously emphasizes the immediacy of the arrest reckoned from the commission of the crime. Hence, mo nang gitawag na tong hot pursuit exception. Okay? In the case of People versus Sindana, an arrest was made based on the information from unnamed sources a day after the crime was committed. And it was held by the Supreme Court to be invalid because it was from unknown sources or unnamed sources. In Rolito Go versus Court of Appeals, the accused was arrested 6 days after the commission of the offense. Also, the Supreme Court said this was not valid because the offense has not just been committed. In Posadas versus Ombudsman, a warrantless arrest was invalidated because it was made 3 days after the commission of the crime. It must be emphasized, no, that the personal knowledge referred to under hot pursuit exception does not refer to actual knowledge of the crime because the officer did not witness its commission. The knowledge referred to here is the knowledge that the crime was committed even if it was not committed in his presence. The Supreme Court also emphasized the distinction na in flagrante delicto exceptions daw, the person making the arrest himself witnesses the crime. But in this exception, in hot pursuit exception, the person making the arrest knows for a fact that a crime has been committed. Okay? So, eh, alright. So, muna ang hot pursuit exception. So, there are instances, no, wherein the Supreme Court said that these are well within the hot pursuit exception. For example, in the case of People versus Akol, two robbers divested a passenger of a jeepney of their belongings, including the jacket of one passenger. The passengers immediately sought the help of the police officers, which formed a team to track down the suspects. So one of the passengers who went with the responding police officer saw one of the robbers casually walking in the same vicinity and wearing his jacket. So here, the warrantless arrest of the accused was sustained by the court as well within the hot pursuit exception. In the case of People versus Herente, the Valenzuela police station received a report of a mauling incident which resulted in the death of the victim, who received a massive skull fracture caused by a hard and heavy object. The policemen saw the dead victim in the hospital and saw the instruments of death in the crime scene. So right away, the officers went to the crime scene and found a piece of wood with bloodstains, a hollow block, and two pouches of marijuana. A witness told the police that the accused was one of those who killed the victim. So they proceeded to the house of the accused and arrested him 3 hours after the alleged killing. So the court ruled that based on their knowledge of the circumstances of death of the victim and the report of an eyewitness in arresting the accused, the officers had personal knowledge of facts leading them to believe that it was the accused who was one of the perpetrators of the crime. Also, in the case of Abilita versus Doria, the petitioner alleged that he was arrested based merely on an information relayed to the police officers about a shooting incident and that they had at the time of the arrest no personal knowledge of the facts. So the court found that as soon as the police received a phone call about a shooting incident, the team was dispatched to investigate. The investigation disclosed that the victim was wounded and that the witnesses tagged the petitioner as the one involved and that he had just left the scene of the crime. So after tracking down the petitioner, he was invited to the police headquarters, but the petitioner who initially agreed sped off, prompting the authorities to give chase. The court here ruled that the petitioner's act of trying to get away, coupled with the incident report which they investigated, is enough to raise a reasonable suspicion on the part of the police authorities to the existence of probable cause. In a fairly recent case, the arresting officers went to the scene of the crime upon complaint of the offended party that he was mauled less than an hour after the alleged mauling. So they saw the blooded stain of the victim and how the latter identified the assailants. The accused, when confronted with the police, did not deny the mauling, although they gave another version of the incident. So these circumstances qualify as the officer's personal knowledge of the commission of the crime to justify the warrantless arrest. So when making the arrest, no, by virtue of a warrant, the officer shall inform the person to be arrested of the cause of his arrest and also the fact that the warrant has been issued for his arrest. The information need not be given when the person to be arrested flees, of course, kung naikyas na hindi nagkaka-inform, or forcibly resists, or giving the information will imperil the arrest. Okay? Also, the officer need not have the warrant in his possession at the time of the arrest. However, after the arrest, the warrant shall be shown to the person arrested as soon as practicable if the person arrested so requires. Okay? Also, the officer assigned to execute the warrant of arrest has, after the arrest of the accused, the duty to deliver the person arrested to the nearest police station or jail without necessary delay. And also, an arrest may be made on any day or in any time of the day or night. Okay? Pwede weekends, pwede gabi so any time and any day of the night. Sections 8 and 9, no? So these sections provide for the procedure in effecting arrest with or without a warrant or in making citizens arrest under the circumstances contemplated in Section 5 of this rule. So basahan lang ninyo the method of making the arrest. Section 10, 11, and 12, these sections provide for permissible means and force which may be availed of for the purpose of effecting the arrest under the stated situations. So in sections 11 and 12, it now permit only an officer to break into a building to effect an arrest. Hence, such right is not extended to a private person, even if the purpose of the said private person is to make an arrest. Nevertheless, a private individual is exempt from criminal liability for trespass to dwelling whenever he has done so for the purpose of rendering some service to humanity or justice. Kaning section 13, this regulates the method and the exercise of the right to effect a rearrest or recapture of the arrestee. So the situation here differs from that contemplated in katong section 5 paragraph C of Rule 113, wherein the person arrested has escaped from detention. Here, sufficient na nga the arrestee has only been lawfully arrested, and this provision is in effect an extension of the rule on citizens arrest. Okay. In this section, the person arrested has the right to an attorney or the right to be visited by a relative. So here it states that any member of the Philippine bar shall, at the request of the person arrested or at another acting in his behalf, have the right to visit and confer privately with such person in the jail or any other place of custody at any hour of the day or night. So ang lawyer, bisa gabi, pwede actually, under the rules, pwede mo visit sa jail or sa police station ba ron, nga na. But ang relative is subject to the regulation sa jail or sa police station as the case may be. Basically, na sila yung mga schedule, okay? Miranda rights. Okay. So, Miranda rights under the Miranda Doctrine, which originated in an American case of Miranda versus Arizona. Ang person arrested has the following rights. Okay. So, any person under custodial investigation has the right to remain silent. Mauna ang isulti sa mga pulis, every time they would arrest someone. So, you have the right to remain silent. Anything you say will be or can and will be used against you. You have the right to an attorney. And if you cannot afford an attorney, we will provide you with one. So these are the rights that an arresting officer must give to an arrestee in order to also effect a valid arrest. What is an effect if an arrest is illegal or invalid? So these would lead to several consequences. Una, the person of the accused will not be acquired by the court, be criminal liability on the part of the law enforcers for illegal arrest. And kanigud pod, any search incident to an arrest becomes invalid and would render the evidence acquired as constitutionally inadmissible. So it bears stressing that the illegality of the arrest affects only the jurisdiction of the court over the person of the accused. And also, even if warrantless arrest is later proven to be invalid, such fact, according to the court, will not be sufficient to set aside a valid judgment rendered upon a sufficient complaint after a trial free from error. So, also take note of that. So that's Rule 113, or the provision or the rule on arrest. On our next meeting, we will discuss Rule 126,